Okay, John, I want to come out and talk to you about a case, and again, you don't have to tell us any details unless you want to, but I understand you've gotten a sexual assault charge dismissed recently out there. On what grounds? Why would the prosecution say, okay?
Well, on a number of grounds. The grounds that were proposed by the district attorney probably don't necessarily correlate with our position on why it was dismissed. It was our position that it was consensual all along. That case was dismissed about 5 hours ago and was set to go begin trial next week.
We hear about them requesting the medical records on the part of the accuser. Some people say, you know, is this dirty? Is it fighting unfair? Well, you want to know the psychological condition. What would you be doing if you were his Colorado counsel right now to prepare a defense?
Absolutely. What you want to do is try to get these records if they're attainable. There are a lot of privileges that apply. There are medical records. I'm not aware that the privilege has been waived. But to the extent that they exist and they are relevant information that will help the jury make a decision on credibility, the central issue in this type of a trial, then you have to go for it. Now, the judge may find that you're not entitled to it, and it may be that you actually are not entitled to it under the law, but you certainly, in doing the best job you can for your client, have to find that information and then take a look at it and see if it's relevant. For example, if they were to find this information, if the law will permit them to have access to it, and they find that the victim is delusional or that the victim has issues in regard to self-abuse of some kind, then those are issues that I think a juror, even a reasonable juror in this case, would feel cheated if they did not find that information, if that information wasn't presented when they have to make the central determination of credibility to decide innocence or guilt.